Good afternoon. My name is Matthew Esslinger. I'm an attorney with Chartwell Law. I'm here with Lori DePolis and John Spadea, both partners at Chartwell Law. I'm a partner as well. We're here to talk about a recent case, David Gabriel versus WCAB, Procter and Gamble, essentially discussing a medical-only NCP and the ramifications or possible ramifications if an employer does not issue that document, including a possible award of a penalty and unreasonable contest fees. Lori will be taking the employer counsel's position and arguments. Jonathan will be taking the claimant side, and then we'll have some back and forth and discussion regarding this case and the ramifications for your case going forward. Lori, can you give us some background of this David Gabriel case and essentially the background of the procedural stance and some of the facts of the case?
Yeah, sure, Matt. The petitions in litigation were a claim and penalty petition. The penalty petition alleged unreasonable contest counsel fees for essentially the failure of the employer to issue a bureau document. There was an injury that occurred in February of 2016. This petition was actually filed, these petitions were actually filed in August 2017. The injury involved a puncture wound to the left elbow of the claimant. The injury did occur in the course and scope of employment. The employer was properly notified. Claimant admitted during the proceeding that the claim petition was really filed just out of a precaution. Because there was no bureau document filed, he wanted to make sure there was something on the record that he did sustain an injury. Claim at the time of the filing, he did not have a doctor's report or supporting his claim petition. Employer did pay for some initial medical bills, but like I said, never issued a bureau document, because essentially what the claimant did was had this injury, got some treatment, never lost time from work. And so the employer just thought this claimant was gonna, go away. So what happened then, when the claim petition was filed, the attorney for the employer filed an answer denying all the allegations in the claim petition. That initiated a hearing. So the parties went to an initial hearing. At the time, claimant had nothing to support his allegations in the claim petition. A second hearing was then scheduled for claimant's testimony, and he laid out essentially the facts and what happened to him. There was clearly an injury in this case. Then a third hearing was filed, at which time claimant did get some treatment, and he provided a doctor's note that he sustained a laceration of the branches of the posterior cutaneous nerve that resulted in permanent loss of sensation. So he did provide a doctor's report. A fourth hearing was held, and at this point, the employer said, we're going to stipulate to the fact that claimant did sustain an injury for medical purposes only. At that point, claimant's counsel refused to enter into a stipulation. And essentially at that point, the employer was forced to issue the medical-only NCP, which they did in March 2018, which was clearly outside of the 21-day requirement. The WCJ granted the claim petition. The WCJ did not award penalties or unreasonable contest counsel fees. The appeal board essentially affirmed the WCJ's opinion. But when it got to the Commonwealth Court overturned the unreasonable contest portion and remanded it to the workers' compensation judge to determine the amount of the counsel fees. They essentially based the opinion on the fact that there was no bureau document filed in this case. And had the bureau document been filed, the claimant would not have pursued a litigation. And they dismissed the fact that there are no additional injuries alleged in this petition. The injury alleged related to the same injury that occurred in February 2016. So that's essentially the facts of the case. And from employers' perspective, I think that we, perhaps when they filed the answer, knowing that the injury did occur, they could have avoided litigation, accepting a puncture wound and then forcing the claimant to defend or prosecute a review petition, which I think would have gotten them out of the unreasonable contest counsel fees.
And John, taking your normal employer's captain hat off and putting a claimant's captain on, which I noticed you do have a hat behind you. I don't know which claimant or defense counsel. From your review of this case, what were the arguments you saw from a claimant's counsel's perspective or a claimant's perspective?
Yeah, so it's pretty straightforward for the claimant's attorneys. The act is clear. You have 21 days after notice to either accept or deny the injury, and that is it. You do not get to play games. And in this case, this specific injury, we're not talking a strain or a pull. This was a very discreet, the arm was punctured by a piece of wire. They knew it happened. They paid benefits, and I believe, according to the record, there was communications from either the employer or the adjuster notifying the claimant that they're paying the medical treatment in this case. You have to pick up the injury. At a minimum, you have to acknowledge it, even if that be with a notice of denial, then we can litigate that issue. But from the claimant's side of it, the act clearly states you have 21 days to either accept or deny the injury. You did not do that, and as a result, we now have to file the petition. From also a claimant's perspective, Lori is right, and it is true. The claimant in this case did not lose time. There was only a minimal amount of treatment, but in the claimant's mind, that injury could worsen over time. There could be a future need for treatment. There could be other aggravations and exacerbations. So I would say to employers or insurance carriers that may come across this, even if you have a one-time distinct event, there is an incentive for claimants to get the injury recognized and get it on the books. That way, if something arises in the future, they can have the injury already documented. And I think that was probably one of the driving forces for the claimants in this case to get the injury recognized. Lori, knowing that, I think you mentioned, and I want to just drive home the point here, the defense did a strict denial with their answer. How do you think that affected the case?
Well, I think it forced the case into further litigation. I think that if they would have filed an answer, like you said, acknowledging, I think it was a clear injury here. I didn't see that they put forth any affirmative defenses to this. So I think if they would have just acknowledged it and said he did sustain a puncture wound, but he received medical treatment and he didn't lose any wages, I think that would have forced the claimant then to pursue a review petition and, have to go through with a deposition or an IME. The employer would do an IME. I think the employer, though, quite frankly, this is kind of a situation where somebody gets injured at work, they barely get any treatment, and they go on about their business as usual. So the employer wasn't thinking that he or she was ever going to hear from this claimant again, and that the case would just go off and 3 years would pass and they'd be fine. Some employers might not want to spend the additional time or money to file a medical only NCP. I'm not saying that that's the advice I would give somebody. I think you should always recognize an injury, whether it was in this case through the answer or via a medical only NCP. So I guess if this case were mine, I might have pushed the argument, and I think the employer's counsel did, that it was just a puncture wound and there's no evidence that he sustained any further issues other than the puncture, which was healed. But there's no evidence I get of a full recovery. So, I think that the employer could have nipped it in the bud pretty early on here. But again, I don't think the employer was thinking at the time that this claimant was going to go out and hire counsel. And he did hire counsel and filed a claim petition. And then it was counsel claimant's counsel who was refusing to stipulate and, force the matter to go to decision. And so I think it's in part the claimant's counsel's fault. The claimant was not treating at the time the claim petition was filed. It's not as if the claimant needed any ongoing medical treatment. It's not like the claimant was losing wages. So I just think it was a little overreaching on the part of the claimant's counsel to not just, stipulate and withdraw the petitions.
And if I can just interject as far as Lori's last or points there, as far as the evidence, I absolutely agree from my read of this was that there were several hearings, and Lori, correct me if I'm wrong, where the claimant's counsel did not have any medical evidence, which to me indicated the claimant was not treating. You indicated the claimant had, I think, stopped working for this employer. So in all respects appeared that claimant was going on his own way. And John, you mentioned games, and I think really that was what was occurring here from a claimant's counsel's perspective, that they were driving this thing. And my review was that it was being quite candid that if the employer counsel maybe would have submitted something, or as Lori, to your point, agreed to some aspect of the injury, maybe they could have avoided this or submit some sort of medical evidence in response. John, what do you say as far as from a claimant's perspective, if you have a claimant who goes to a different job, is really not actively treating, why not just let sleeping dogs lie? Why file this petition?
Well, this one's hard because as the defense attorney in me, I am sympathetic to counsel's efforts in this case to kind of resolve what would be a minor issue. In the best light, the claimant and the claimant's counsel can argue that, look, all of that is secondary to the fundamental issue that you did not issue. You did not issue with the Bureau the requisite documents. That's why we're here now. Even after the first hearing, even after filing the petition, you're still litigating months down the road. Yes, my client in theory is with a new employer. Yes, my client is not treating. That may change in the future. But at this point, because we have been forced to litigate all of these months and because you have taken this long of time, we are not going to just get out easily. We believe, we being the claimant, we're entitled to unreasonable contest attorney's fees and penalties. And I think some of that is, if I can be so bold, a cash grab. But I think that's a lesson that you insurance carriers, you employers, and other defense counsel need to know. The workers' comp bar, by and large, is pretty congenial, but you cannot count on that. You have to do your due diligence, get an IME, even in cases like this, or be prepared to get one. If at the, as Lori said with the answer, follow the facts. If there is an injury, at least recognize it as a med only and move on, force them to litigate. Or kick out that med only as soon as possible. But with that, Lori, do you have kind of one take-home message or one bottom line message that employers or insurance carriers can take from this case moving forward?
Yeah, I think it's exactly what you said, John. That you have to, if someone does get injured, you should acknowledge it in some way. And do your investigation, make sure that you have, that the injury is something that should be accepted. And that, but if you don't do that as an employer, if you want to just see if the claimant's back to work, he didn't need much treatment or she didn't need much treatment, and you don't want to issue the medical only NCP, when a claim petition is filed, I think at that point you need to either issue the medical only NCP or have your counsel stipulate to the facts, follow the facts, and then force the claimant to have to do, meet a burden in, alleging disability or a more severe injury.
And I would add on to that, Lori, that I would recommend that it's a case-by-case basis. There can be advantages for the employer to file a medical only. There was a case several years back, Sloan, which essentially said because the carrier filed a medical only, that started the statute of limitations. And so that any subsequent payment of medical bills, while they may be related to an alleged injury, the fact that a medical only was issued and there was denying disability gave the employer some protections there. So I think it's a case-by-case analysis, but a medical only can be useful. And also I think that it puts some control in the carrier's possession as far as what they are accepting. And I also would add to that is, and this is slightly off at the topic, but any sort of accepting document, whether it be a medical only or full notice of compensation payable, I would encourage carriers to pay particular attention to what injury description you're putting in there, to do the least amount of or the lowest description of injury possible, or least amount accepted, a sprain type strain, not pain, anything like that. And in this instance, I think if you do a medical only, it's a sprain strain, the claimant's counsel still might file a petition arguing that there should be an expanded injury. But then, Lori, to your point that it's a review petition you're fighting, and maybe it's a claim as well, but there is some nuance there. But again, I would say from my perspective, I just think it's a case-by-case analysis. And I do understand that the position of some of the carriers that, well, everybody's gone their separate ways. Why do we want to rock the boat? But this is a case, I guess, that come back to bite you potentially. So with that said, any other comments, John or Lori?
Real quick, just to piggyback on both what Lori and Matt said, temporary notices are your friends. They are designed for this situation. If you are hesitant to pick up an injury completely, tick out a notice of temporary compensation payable. That gives you another 90 days to investigate, gather facts, gather medical. And at that 90 days, you can either let it run its course and convert to a full notice, or issue the notice stopping and the notice of denial to deny the claim. But don't be afraid of notices, or the temporary notices.
And I would just say with that, obviously, to make sure, keep that 90-day period in mind, because you don't want a situation where it converts. So with that, and Lori, any additions?
No, I think we've covered everything. Okay.
Well, thank you everybody else for participating and viewing this. And if you guys have any questions, there are email addresses for Lori, Jonathan, and myself on the Chartwell website. We're happy to answer any questions relative to PA workers' compensation, which all three of us do. We represent employers and carriers. So thank you for your time, and hope you have a great rest of your day.
Thank you.